Administrative law in the post-liberalization era. 1991 onwards. In 1991, India adopted liberalization, privatization, and globalization (LPG) reforms. This structural shift fundamentally altered the role of administrative law. Administrative law developed gradually with the expansion of the state. Post-1991 era state transformed to regulatory state, and the primary focus of administrative law is on state market regulation, SEBI, TRAI, CCI, PPP models, and transparency, RTI. Shift from direct provider to regulatory state. The state withdrew from directly running several commercial monopolies and took on the role of an independent umpire, regulator to ensure fair market competition and consumer protection. Proliferation of independent statutory regulators. Specialized regulatory authorities were created with blended legislative, executive, and judicial powers. SEBI, Securities and Exchange Board of India, regulating capital markets. TRAI, Telecom Regulatory Authority of India, regulating the telecom sector. CCI, Competition Commission of India, preventing anti-competitive agreements and abuse of dominant position. CERC and PNGRB, regulating electricity, petroleum, and natural gas. Public-private partnerships, PPP, and disinvestment. Administrative law expanded its scope to govern government tenders, public-private contracts, and concessions under the non-arbitrariness standards of Article 14. Ramana Dayaram Shetty v. International Airport Authority of India. Focus on transparency and good governance. Enactments like the Right to Information Act 2005 transformed the relationship between citizens and the bureaucracy by ending bureaucratic secrecy and establishing statutory transparency.